truth is not merely a desirable attribute in criminal investigations, it is the indispensable foundation on which justice is built. Law enforcement officers are endowed with extraordinary powers to detain, to search, to interrogate, to arrest, and to initiate the machinery of the criminal justice system. These powers are premised on the belief that officers will wield them with fidelity to the truth, even when it is inconvenient, complex, or runs contrary to institutional or personal biases. This chapter explores the central role truth plays in criminal investigations. It examines how investigative integrity, truthfulness in reporting and documentation, and adherence to standards of evidence collection shape outcomes not only for individual defendants, but for the justice system as a whole. When officers act with candor, they serve not just the ends of law enforcement, but the broader ideal of a fair and trustworthy government. When they do not, the consequences are often catastrophic, extending far beyond the walls of a courtroom. Investigative integrity. Investigative integrity refers to the consistent and principled adherence to ethical and legal standards throughout the fact-finding process. It begins the moment a call for service is received or a crime is suspected and continues through every step of the investigation, interviewing witnesses, collecting physical evidence, analyzing forensic data, and building a narrative that will eventually be passed to prosecutors. At its core, investigative integrity demands that officers pursue the truth, not merely the facts that support a preferred narrative or help secure a conviction. This means following leads even when they are exculpatory. It means documenting inconsistencies rather than smoothing them out. It means understanding that law enforcement is not in the business of storytelling, but in the search for truth even when the outcome is ambiguity, doubt, or dismissal. Investigative integrity is not just a philosophical virtue. It is a legal necessity. Investigations conducted with bias, dishonesty, or reckless indifference to truth often result in tainted prosecutions. They produce wrongful arrests, skewed case files, and suppressed or ignored evidence that can irreparably harm the innocent and allow the guilty to go free. High-profile exonerations frequently stem not from the discovery of new facts, but from the revelation that old ones were distorted, ignored, or deliberately hidden. The importance of this integrity cannot be overstated. Each investigation is not merely an exercise in criminal justice, it is an exercise in government legitimacy. When officers lie or omit critical facts in their investigations, they are not just compromising a case. They are betraying the very principles that justify their authority. Standards for evidence collection. The collection of evidence is the procedural backbone of criminal investigations, and it must be carried out with rigorous adherence to objective standards. These standards, codified in law, department policy, and best practices, exist to ensure that evidence is collected fairly, preserved accurately, and presented honestly. The chain of custody. Maintaining a clear, unbroken chain of custody is essential to proving the authenticity and reliability of physical evidence. Every transfer of evidence from the crime scene to storage to the courtroom must be documented, with identities, times, and purposes recorded in detail. Any lapse in this chain raises the possibility of contamination, tampering, or fabrication. Officers who falsify or fail to maintain this record undermine the legal value of the evidence and create opportunities for defense attorneys to challenge its admissibility. More importantly, such lapses cast doubt on the overall credibility of the investigative process and can lead to the exclusion of critical material in trial proceedings. Forensic evidence and bias. In recent years, scrutiny of forensic science has revealed that many techniques once accepted as reliable, such as bite mark analysis, hair comparison, and even certain fingerprint techniques, lack empirical validation. Truthfulness in investigations requires officers to acknowledge the limitations of these tools and avoid overstating their evidentiary weight. Additionally, forensic analysis must be conducted independently and free from confirmation bias. Officers who communicate their theories or expectations to forensic experts risk unintentionally influencing the results. Forensic labs should operate independently from law enforcement agencies to preserve the objectivity of their findings. Search and seizure law. The Fourth Amendment governs the collection of evidence through search and seizure. It requires officers to obtain warrants based on probable cause and to specify the places to be searched and the items to be seized. Falsifying warrant applications, exaggerating probable cause, or exceeding the scope of a warrant not only violates individual rights, but risks suppression of evidence and dismissal of charges. Some of the most consequential misconduct in modern policing has involved unlawful searches based on false information. For example, in the 2020 police killing of Breonna Taylor, a key issue was the falsification of information used to obtain a no-knock warrant. Investigators who disregard constitutional boundaries erode public trust and render otherwise legitimate investigations legally defective. Truthfulness in reporting and documentation. Perhaps the most overlooked but critical component of an officer's duty to tell the truth is the written word. Police reports, supplemental narratives, incident summaries, and affidavit statements form the written record that courts, prosecutors, defense attorneys, and the public rely upon to evaluate what happened. These reports are treated with a presumption of reliability. When officers lie in these reports or shade the truth through omission, they are introducing falsehoods into the judicial bloodstream. The power of the report. Police reports carry disproportionate influence in the legal process. Prosecutors often use them to decide whether to file charges. Judges rely on them when setting bail or issuing warrants, and defense attorneys base much of their early case strategy on the contents of the report. This immense influence makes accuracy paramount. A misleading police report is not a minor administrative issue. It can lead to unjust incarceration, plea deals based on falsehoods, and trials where the defense never had access to the real facts. Even seemingly small distortions, such as omitting the presence of exculpatory witnesses or phrasing a suspect's behavior in an incriminating light, can dramatically alter the legal outcome. Intentional falsehoods. Intentional misstatements in police reports constitute perjury when made under oath and official misconduct in almost every jurisdiction. Despite this, many law enforcement agencies have historically treated these violations as internal disciplinary issues rather than crimes. This double standard is increasingly under challenge as public awareness and litigation pressure force agencies to reconsider leniency for report padding or creative writing. Civil rights lawsuits, wrongful conviction settlements, and public scandals have exposed the long-term dangers of institutional tolerance for false documentation. Officers who lie in reports not only risk their own careers, they endanger entire cases, put prosecutorial agencies at legal risk, and compromise the integrity of their departments. The role of supervisors. Supervisors bear a crucial responsibility in maintaining truthfulness in documentation. Field sergeants and watch commanders must review and approve reports with a critical eye, not simply rubber-stamp the narratives provided by subordinates. A culture of candor begins with leadership, and supervisors must model and enforce the expectation that reports will be truthful, thorough, and fair. Incentives to misrepresent. Understanding why officers sometimes fail to adhere to truth in investigations requires an honest examination of the incentives and pressures that shape police work. Institutional pressure for convictions. Departments are often evaluated based on clearance rates and successful prosecutions. Officers may feel pressure explicit or implicit to ensure their arrests result in convictions. This can create an environment where omitting inconvenient facts or stretching the truth feels justifiable in service of a greater good. Such logic, however, is deeply corrosive. Justice is not about securing convictions at any cost. It is about getting it right. The us versus them mentality. The adversarial nature of policing, especially in high-crime areas, can foster a mentality where officers see themselves in conflict with the bad guys. In such an environment, rules may be bent, and the truth may be seen as negotiable. Officers may justify misstatements or omissions as necessary to prevent dangerous individuals from escaping punishment. Yet the cost of this mentality is the erosion of individual rights and the moral high ground upon which law enforcement legitimacy depends. Lack of accountability. Many jurisdictions lack effective systems to track and discipline officers for untruthfulness. Even when misconduct is discovered, union contracts, arbitration processes, and weak internal affairs units may shield officers from consequences. Without meaningful accountability, the disincentive to falsify or omit crucial facts weakens. Departments must develop systems to track credibility issues, maintain transparency, and implement meaningful penalties for violations. Technology and truth. Modern technology has introduced new tools for promoting truth in investigations, but also new challenges. Body-worn cameras. Body-worn cameras, BWCs, have become critical tools for increasing transparency. When properly deployed and reviewed, BWCs can validate officer reports, refute false allegations, and uncover misconduct. However, the utility of BWCs depends on consistent usage policies, penalties for non-activation, and full disclosure to defense counsel and the public. Digital evidence management. The proliferation of digital evidence, including surveillance footage, GPS data, cell phone records, and digital forensics, means that officers must possess both technical competency and a strong ethical compass. Mishandling or concealing digital evidence can be as damaging as lying in court. Agencies must develop strong policies for digital integrity and provide training that emphasizes the importance of transparency in handling and interpreting digital material. The cost of abandoning truth. The consequences of failing to uphold truth in criminal investigations are widespread and devastating. They include wrongful convictions, where innocent individuals lose years or decades of their lives; civil liability, with cities and departments paying out hundreds of millions in lawsuits; damaged community trust, which makes future investigations harder and undermines cooperation; institutional decay, where good officers become disillusioned and bad behavior becomes normalized. Conclusion. The role of truth in criminal investigations cannot be overstated. It is not a passive value, but an active duty, one that must be enforced by policy, instilled by training, modeled by leadership, and protected by oversight. Officers are not mere participants in the justice system, they are its architects. Every decision they make, every report they write, and every statement they utter either reinforces or erodes the foundation of justice. Complete candor is not merely about avoiding lies. It is about embracing a full and honest search for the truth. In every investigation, officers must remember that their ultimate loyalty is not to conviction statistics, departmental approval, or prosecutorial cooperation. It is to the Constitution, the public, and the ideal that justice can only prevail when it is built on truth. I am a dedicated author and researcher specializing in the intricate nexus of technology, law, and government. My extensive body of work includes a diverse array of books, scholarly articles, and policy papers that delve into the evolving challenges and opportunities presented by technological advancements within legal and governmental contexts. Through rigorous analysis and insightful exploration, I examine how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain shape and are shaped by legislative frameworks, regulatory practices, and public policy initiatives. My publications aim to bridge the gap between technical innovation and legal governance, providing comprehensive resources for policymakers, legal professionals, technologists, and academics alike. By addressing critical issues like digital rights, cyber law, technology-driven governance, and the ethical implications of technological integration, my work contributes to the development of informed and adaptive legal systems capable of responding to rapid technological change. I am committed to fostering a deeper understanding of how technology influences governmental operations and legal standards, and vice versa, thereby promoting the creation of robust, equitable, and forward-thinking policies. In addition to my writing, I actively engage with government agencies, legal institutions, and technology firms to offer expertise and collaborate on initiatives that ensure the responsible and effective implementation of technology in public spheres. My dedication to exploring and elucidating the intersections of technology, law, and government underscores my commitment to advancing knowledge and facilitating informed decision-making in an increasingly digitalized world.